Hi, my name is Megan Gower. I am graduating this May with a double major in history and political science, and in the fall, I will be attending law school, which is how I got the idea for my thesis. My thesis title is Jurors Acting as Crystal Balls Future Danger Determinations in Texas Capital Sentencing, which is a bunch of words to say that my thesis focuses on a very specific part of how people are sentenced to death in the state of Texas. So, to be sentenced to death in Texas, there's actually two separate trials. The first trial decides the issue of guilt or innocence, and then the second trial decides the issue of punishment. So during the punishment trial, jurors are given two special issues to answer. The first is the focus of my thesis, which is future danger. So jurors are asked to determine if there is any probability that the convicted person would pose an ongoing threat to society. If jurors answer no to this question, then an automatic sentence of life in prison without the possibility of parole is given. If jurors answer yes, they may move on to consider the second special issue, which is mitigation. So jurors are given the life story of the person on trial, and that could include things such as if there's an issue of intellectual disability, if there's an issue of severe mental illness, if there's a history of extreme childhood poverty, abuse, or neglect, and they're asked to consider the life story and what they believe the culpability of this person, the culpability this person had in the murder, and determine the appropriate punishment. So ultimately, jurors can't decide whether or not life or death is appropriate before deciding if the person is a future danger, which is why this issue is so important. So this issue came about with the 1972 Supreme Court case Furman v. Georgia, where the Supreme Court put a national moratorium on capital punishment because it said that the current way it was being implemented was arbitrary and capricious and unconstitutional. The issue with this case was while it said states needed to revise their statutes, none of the justices could really agree on why they needed to do this or the way that they could revise their statutes to make them constitutional. So my thesis kind of goes by each concern of each justice in the majority opinion and shows why the current state of Texas capital punishment as a result of future danger determinations is really inseparable from how it looked when the Supreme Court put a moratorium on capital punishment with Furman in 1972. So one of the main concerns raised by the justices in Furman was that there was some clear evidence of racial discrimination in how capital punishment was being doled out. If you look at the current composition of Texas's death row, approximately 44% of those on death row are Black, whereas 2019 census estimates posit that only about 13% of the overall population is Black. Now, we know from other studies that if you control for factors such as socioeconomic status and education, crime is committed at roughly equal rates across all racial and ethnic groups. Therefore, it doesn't really make sense why there's this great disparity. So already the current state of Texas capital punishment raises that concern that was raised in Furman. Other justices took issue with the fact that jurors were given very little guidance or unclear guidance as to how to sentence people to death. And so if you remember from earlier, jurors are tasked with determining if there is any probability that the convicted person would pose a continuing threat to society. But probability isn't defined. So jurors could find that there is a 0.1% probability, or they could find that there's a 99% probability, and either would technically be correct. And the American Bar Association itself has raised concerns for specifically this part of Texas capital punishment and stated that it needs to be revised. And so overall, the concurrence in Furman took issue with the fact that death sentences couldn't be given in an arbitrary or capricious manner. And the resulting effect of future danger determinations in the past 50 years and the way they've come about is often through expert psychiatric testimony of expert witnesses deeming individuals, severe sociopaths or psychopaths or having antisocial personality disorder, and predicting future behavior for the rest of their lives, despite the fact that professional organizations for psychiatrists and psychologists have been saying since the late 70s, actually, that this is a completely inaccurate determination. And furthermore, if we look at longitudinal studies on capital inmate behavior, they actually show that approximately 95% of people convicted of capital murder can live perfectly peacefully in penal institutions. Less than 0.2% are actually at risk of killing again. So overall, this issue kind of fits into the arbitrary and capricious concern that the original justices had in Furman. And therefore, my thesis proffers that this issue should not be considered in capital sentencing. The only thing that we should be considering is mitigation and culpability, because if capital punishment is to be preserved for, ostensibly the worst of the worst offenders, then that's what the jury should be focusing on and not arbitrary standards which professional boards have deemed for years shouldn't be used and aren't reliable. So thank you for listening thus far. I hope it wasn't too hard to get through. I hope you have a great rest of your day.